Hey, this one's for landlords. So if you are a residential landlord, this is for you. And specifically, this topic's going to be about evictions. I'll do another one on leases and security deposits and what should be included, what can't be done, that kind of thing later. But this one's just for evictions. So you've got somebody who hasn't paid their rent, they've gone past any type of grace period that they're owed. Here's what you do. Number one, you got to put a 3-day notice up on the door. You do that the day after the rent is due. So if you got rent due on the 1st, you got a grace period until the 5th. They don't pay. You put the notice, 3-day notice, up on the door on the 6th. You don't wait. Doesn't matter what the story is. You got to get that 3-day notice up. I always say take a picture of it so you've got something that has kind of a date stamp, time and date stamp, so you know it was put up on the 6th. And obviously keep a copy of that 3-day notice for yourself. If they don't pay within the 3 days, then you file your eviction action. It's going to be a complaint, it's going to be a lawsuit. You're going to file it in whatever county the real estate's in, usually in municipal court or the eviction court, whatever version that is for you. That complaint is going to have, you got a choice of 2 counts. The first count, or the first claim in your complaint, should be what's called restitution, meaning you want possession of the property back. Super basic, just says, listen, tenant had a lease with you, you attach a copy of the lease, the rent was due by this date and then this amount, they didn't pay it, you posted your 3-day notice, they didn't pay, they're still in the property, they have to vacate. So you're asking the court to give you possession of the property back. That's your first claim, it's for restitution. The second claim, that's up to you whether or not you want to include it, but that is for past due rent, damages, that sort of thing. So, that just depends on what kind of tenant you have. Are they collectible? Do you know where they work? Do you know that they're going to be able to pay a judgment if you get a judgment against them for the past due rent? So that's up to you whether or not you include it. But that would be your second claim. If you decide not to include a claim for past due rent, then all you have is that first count for restitution. So you file that complaint. Typically, eviction court's going to set a hearing. The fastest is maybe 2 weeks. More realistic is 3 weeks. After COVID, could be 4 weeks, but they're going to set a hearing where you and the tenant show up, and they're essentially going to ask the tenant a couple of things. They're going to say, number one, were you behind on rent? Did you receive a 3-day notice? Are you still behind on rent? And do you still live in the premises or live in the unit? And the tenants, if they say yes to all those questions, then the court's going to say, well, we're giving restitution back to the landlord, so we're giving possession back to the landlord. They're going to find in your favor as the landlord. What happens next? Well, at that point, the court's going to give you the ability to have the tenant set out. So if the tenant doesn't leave within a few days after eviction being granted, you can file for a red tag or set out with usually with the bailiff with the court. They'll arrange to have the sheriff there, and you actually hire some people and move all the tenant stuff to the curb. I mean, that's what a set out is. So most people try to avoid that, especially on the tenant side. Once they've gotten eviction in their name, then they just want to get out and get their stuff out. But worst case, that's what you end up doing, is doing an actual set out. So that's the perfect example of when an eviction goes right and there's no issues. So what are the key concerns you as a landlord should have? If you don't post that 3-day notice, don't file that eviction, right? You got to post that 3-day notice first. If you file for your eviction, beware that, at least in Ohio, the court will grant the tenant a 7-day continuance if they show up for the hearing and they need 7 days for anything. It doesn't really matter. The court's going to grant it. It's going to give them another 7 days. So you be prepared that when you show up for the hearing, it may be continued for 7 days later. Another issue is if your rental is in anything other than your name, like an LLC, the law says you can't represent your LLC. You have to hire a lawyer to represent your LLC. So, you're going to show up at a hearing. If your rental's in an LLC, I'd recommend having a lawyer with you so that they can actually represent the LLC. Now, look, some courts, I would say, don't adhere to that. So sometimes you're going to get landlords who can represent their LLCs, and That usually happens in probably more tenant-friendly jurisdictions, but I'm sorry, more landlord-friendly jurisdictions. If it's a tenant-friendly jurisdiction, then the court's really not going to let you represent your LLC most of the time. So be aware of that. What else could go wrong? So, the landlord gets in there, you get in there and you get into the hearing, and the court, starts listening to the tenant talk about you were supposed to fix the door, the dishwasher, you didn't provide a good place to live, or maybe the tenant countersues you and says you're holding on to the security deposit. Those are all things you got to be aware of. So if you're going to file an eviction action, it's super important that you as a landlord follow the rules, right? Put your 3-day notice up. When you show up at the hearing, be prepared to answer any type of claims that somehow you didn't do the right things. Make sure you aren't holding on to a security deposit. If you have a lease, which you should have a written lease, I'd really advise making sure an attorney's got some eyes on it, just so you don't get yourself into a situation where maybe you crafted your own lease using Google or your friends or whatever, and it's got a bunch of provisions that could get you in trouble. So, all right, hopefully that gives you some guidance on how to do evictions. Don't wait for a couple of months. I know every tenant's got a story, but with how long it takes, at least in Ohio, Central Ohio, Franklin County, from the day you file that eviction, you're probably about 6 to 7 weeks before the tenant's actually out of the premises. So think about it. You're probably losing at a minimum of almost 2 months worth of rent when you got to file an eviction. So you don't want to delay. If you've let them not pay rent for 1 or 2 or 3 months before that, all of a sudden you're losing 5 months worth of rent. So try to avoid that. Be timely, right? They don't pay rent, you get your 3-day notice up there. They don't pay rent by the end of the 3 days, you file your eviction. Yeah, if you're in an LLC, you're prepared with an attorney at the hearing. Be prepared, it could be continued for another 7 days. And then ultimately, when the court gives you restitution or gives you possession of the property back, just remember, you may have to go actually request the court to set out the tenant using the sheriff and your own crews. So that's the wonderful world of real estate investing, I guess. All right, hope that was helpful. Have a great day.